Hi, it's Pranav Barnott from Win Legal. Do subscribe to our Win Legal YouTube channel to learn tips, tactics and strategies to help you through your litigation. Today we're talking about disputes with your property management company. Now, many landlords rely on property management companies to help them manage their buy-to-let properties. But all sorts of issues come about, and we've seen so many in our practice. For example, a management agent who hasn't collected the rent on time or collected any rent whatsoever, or a managing agent who hasn't given the relevant documents that they should give to a tenant, for example, the gas safety certificate or the EPC, or managing agents who just haven't carried out any inspections that they should be carrying out and has let the property just go into a state of disrepair. In this video, we're going to be talking about some of the things you can do when you are up against difficult property management agents. Whenever we see disputes with management companies, the first thing we always look at is the underlying company. Quite often, a management company hasn't been incorporated and it's just an individual using a trading name. But on other occasions, there are actually limited companies that have been incorporated at Companies House. So the key thing to check before any dispute is just to understand who is it that is actually the management agent. Is it an individual or is it a company? And in any event, just to see whether they have any assets. Do they have money? Because we always say do not litigate against a party that may not have any money, because there may not be anything at the end of it for yourselves. Whenever we see a dispute, we always look at the contract. Quite often, landlords and property management companies are asked to enter into signed agreements which set out what the roles and responsibilities are for the property management company and the landlord. It's really important to look out for what the management agent should have done and what they haven't done as set out in the contract. And if you find that they are in breach of the agreement, well, that is something you ought to raise with them. Where there are no terms set out in the agreement, or where there is no agreement whatsoever, you can still have a contract, and you may rely on something called the implied terms, which often require management agencies to act with reasonable care and skill when managing your property. So there's a dispute. Perhaps your property management company haven't done what they should have done and have let you down. So what do you do? Well, the first thing is to do a formal letter. Follow the internal complaints procedure of the property management company. Perhaps that involves writing a letter to the managing director or perhaps the accounts manager dealing with your property. In that letter, set out what the complaint is about, when you first became aware of it, what are the issues, if there's a possible breach of the agreement to set that out, and what is the consequences? Is this causing you a loss? And if so, set out what those losses are. If there's any photographic evidence or any other correspondence between you and the property management company, it may be helpful to also exhibit that to your initial letter of complaint. That should hopefully deal with the matter, but if it doesn't, you could escalate it. And one of the ways in which you can escalate it is by going to, for example, the Property Ombudsman Service if they're registered with them. Or if not that, there are other redress agencies where you can escalate your complaint. But if all of that fails, then sometimes you may want to instruct a lawyer to help you put a bit more pressure on the managing agent to ensure they do what they're obligated to be doing. And when you speak to a lawyer, it will be very helpful for you to come equipped with all the facts. What should the property management company have done? And what in fact are they doing? Do you have any evidence that you can present? Do you have any timelines that you can set out when speaking to your lawyer? Do you have any evidence? And most importantly, do you know what loss this is causing you as a landlord? For example, if your managing agent isn't collecting the rent on time, how much are you in arrears as a result of that? Your solicitors will probably use all that information to do an initial letter before action. And if a satisfactory result hasn't occurred from there, they may well escalate it by way of a court claim. We hope this video has helped in setting out what you can do in the event of a difficult managing agent who isn't doing what they should be doing. But for any more information, please visit our website at www.win.legal. Thank you for listening.